So we are about to begin our webinar. We're going to just give it a minute or two while people are joining our webinar. Thank you for joining us. Again, thank you for joining us. We are just going to give it one more minute while people are signing on. Okay, I'm going to go ahead and begin some housekeeping things before we dive into our public webinar today. My name is Pam Bridge. I'm joined today by Connie Young and our guest speaker, Andy Jacob. We are very excited that Andy will be presenting Wage Garnishment is Too Much Coming Out of Your Paycheck. At the end of the webinar, Andy will be able to answer questions about legal information. Just as a reminder, we can't give legal advice during our public webinars, but we will show you how to apply for services at CLS at the end of this webinar. But if you have questions about what the law says, anything that he went over today, please put that, it'll be in the Q&A. If you look at the bottom of your screen and move to the right, it is one of the options for Q&A. Also, this is being recorded, so it will be on the CLS website after we complete this. I'm just going to talk really briefly about Community Legal Services. We are a nonprofit law firm dedicated to educating, advocating, and litigating on behalf of low-income Arizonans and vulnerable individuals. We are in 5 counties, Maricopa, Yavapai, Mojave, La Paz, Yuma, which also includes our San Luis office. If you are joining us today from one of the other counties in Arizona, I am happy to tell you that we have sister organizations to the southeast, Southern Arizona Legal Aid, and to the north, DNA People Services, which also do the same thing that we do. Between our 3 programs, we cover the entire state of providing access to justice and legal services for our low-income Arizonans. We help people individually with cases, everything from legal advice to direct representation for people who qualify for our services. And we also do a lot of outreach in the community and webinars such as these. If you are from a nonprofit or an agency and would like to talk to us about ways that you can refer cases to us or have us come and join an outreach or speak to your employees, we are always happy to do that and partner with other agencies doing great work in Arizona in order for us to reach the most amount of people. CLS, a big rule of thumb is that we practice civil practice, and we really are there to help assist people with their basic needs: food, shelter, safety. This list shows you some of the areas in which we practice, again, civil practice, that we have close to 80 or 90 employees that are lawyers and paralegals who do this work within our 5 counties. And we also rely really heavily on our amazing volunteer lawyers, such as our guest speaker today. I'm going to turn it over to Connie right now to talk a little bit more about our volunteer lawyers program.
Thanks, Pam. So our volunteer lawyers program is a division of Community Legal Services in partnership with Maricopa County Bar Association. We partner with them to be able to recruit and train private attorneys to be able to help our clients. And it's still part of CLS. In fact, all of those practice areas where Pam read that where we help people with different case types, there are certain priorities in each of our units when they can't take certain cases. They just have too many clients, and they help with certain areas of law, certain priorities, but what they can't help with often comes to our volunteer lawyers program. So we recruit and train volunteer attorneys. They're all doing this pro bono. None of our clients pay for any of the legal assistance they receive from our awesome VLP attorneys. We have attorneys who help clients with bankruptcy law, consumer law, contracts and warranties, debt issues, family law. We have our Family Lawyers Assistance Project. We have a juvenile clinic, and we have landlord-tenant clinic. We also have a PLAP clinic, probate law and probate lawyers assistance project, Social Security law, used car sales, and more. So our attorneys really come to us, from their hearts. They want to serve. They want to help others who can't afford legal assistance. And yes, you would apply through Community Legal Services in order to possibly get assigned one of our attorneys to help with whatever matter you need legal assistance with. So we're so thrilled today to have one of our star VLP attorneys who is going to share with you his expertise on garnishments. Andy, I've known him for decades, I think, over 20 years. We actually went to law school together. And in Andy's first or second life, whatever it was, he was a doctor. He was a really amazing doctor. And we were all in law school. I remember just being so impressed with him. And as things turn out, he is now one of our superstar volunteer lawyers. He helps clients in so many different areas. Whatever we ask him to do, he says yes. And we're so happy that he's willing to train our other attorneys. He's done Attorney of the Day, one of our clinic programs. He's done the Federal Advice Clinic. He's helped with debtor issues in our consumer clinics. And he just is also one of our Community Legal Services board members. He cares so much, gives so much, and we're so grateful for all of Andy's selfless pro bono service, all he does for CLS and VLP. So I'll turn it over to Andy now. Thank you, Andy.
You're very welcome. Today I'm going to be talking about the legal process that can be used to take money out of the paycheck of someone who is subject to a judgment, a court judgment. A person subject to this process is called a judgment debtor. The process is called garnishment. And we're going to explain the law that determines how much can be garnished from a paycheck and what the recent changes have been in that law. We could have we're on the first slide. Yeah, so we could have the next slide. We're going to be talking about something called disposable income. The income we're talking about is your pay, your wages. And garnishment looks first at what is your disposable income, which is your gross pay less the taxes that are taken out of it. Other deductions from your paycheck are still included in disposable income. Next slide, please. So how much can be garnished from your paycheck if there's a judgment against you and the creditor goes through all the court steps to get a garnishment order? Well, prior to December 2022, up to 25% of your disposable wages could be taken out of your paycheck. Next slide, please. But this changed in December 2022 when the electorate passed Proposition 209. And Proposition 209 did this in a couple of ways, but it basically defined how much of your pay would be exempt from garnishment. And that is determined as a multiple of what the minimum wage is. And if you're paid once a week, that exemption is 60 times the minimum wage. If you're paid every 2 weeks, it's 120 times that. If we could have the next slide. Well, the minimum wage in Arizona last year was $14.70 per hour. As of January 1st, it increased to $15.15. And as the law stands, it's going to increase with inflation every year. It can be hard to find what the minimum wage is because the statutes don't change, but the calculation changes. So how much is exempt now from a biweekly paycheck is 120 times $15.15 or $1,818. And I want to emphasize, as long as your disposable wages are below that figure, nothing should be taken out of your paycheck for garnishment. Next slide, please. So basically, this is what we're talking about. What can be garnished? There's two calculations that the employer is supposed to do when they get a garnishment order. One calculation is to say, how much do you earn of disposable wages above 1,818 every 2 weeks? And the other is to take 10% of what your disposable wages are. And then the employer is supposed to withhold whichever of those two calculations is less. Next slide, please. And this chart basically gives 3 examples, which I'll go through, which show you how to do this calculation. So the first thing the employer does is they look and they see, what are your biweekly disposable wages? And I give 3 examples here. It might be 1,800, 2,000, or 2,500. The employer then does these 2 calculations that I talked about. The middle column is basically saying, how much are you earning above the exemption? And if you're only earning 1,800, there's nothing above that. If you're earning 2,000, above that is 182. If you're earning 2,500, it's 700. But that's not the end of it, because the employer also has to say, well, what's 10% of your disposable wages? So the first line, it's $180. Second line, it's $200. The third line, it's $250. So after doing this for these 3 hypothetical people, the employer is not supposed to withhold anything for garnishment from the person who's on the first line, the top line. The person on the middle line, they take the lesser of the 2, which is $182. And the person on the bottom line, they're not supposed to take the $700. They're just supposed to withhold $250. Next slide, please. There's a form. Let's just say you're in justice court. There's a form that is supposed to be sent to the employer. It's called the garnishee's non-exempt earnings statement, and the employer is the garnishee. And I know it's hard to read this form on this slide, so I blew it up. Next slide. Showing the part of it that you need to pay attention to. And the employer fills this form out. I'm looking at lines 5 through 12. Line 5, the employer enters the gross earnings. Line 6, the employer subtracts the taxes, and that's the disposable earnings. Line 7, the employer takes 10% of line 6. And line 7 shows some of the problems that we have. There's no reason since December 2022 that there should be a blank to be filled in on line 7. We're no longer talking about that you might be subject up to 25%. It's 10%. Perhaps under certain circumstances, the court can lower that 10%, but the current law says 10%. So they get one calculation there. And then the next line, 8, the employer has to check off whether you're paid weekly, bi-weekly, however. Then there's a factor that they multiply with. And again, they're giving the employer choices that the employer shouldn't have. The multiple factor, if you're paid biweekly, is 120. There's no option for 60. Then go to line 9, the minimum wage, and that changes each year. It's currently $15.15. Line 10, the employer multiplies the factor from line 8, which if you're paid biweekly should always be 120. You multiply that out, you get the 1,818 that I've been talking about. Line 11, you take line 6 and you subtract line 10. So you take the total disposable earnings and you subtract the exemption and you get a number. And you saw in that previous chart, that's what we did in the center column. And then line 12, you're going to look at, I'm sorry, so line 12, you then have to decide whether you're going to use line 7, which is 10% of disposable wages, or line 11, which is the amount that your disposable wages exceed the exemption. And again, if your wages don't exceed the exemption, they should be entering 0 on line 12. Next slide, please. Mistakes are made. And basically, that's why we're having this talk, because if everything went right, the debtor wouldn't have to do anything. They just accept whatever the garnishment is that's taken out of their paycheck and say, everybody must know what they're doing and must be doing it right. In my experience, that's not true. Mistakes are made. Courts are still applying the incorrect wage exemption. They're still applying what the law was before 2022. And employers can make a math error. You can see when I went through that form, you can stumble over what exactly are you supposed to do on which line. Next slide, please. So you as a debtor, and I'm talking to you as if you are a debtor, you got to pay attention. And you can't be the ostrich and bury your head in the sand and say, this is too distressing, emotionally upsetting, and you just don't pay attention. I've seen people, they don't open court papers. They don't update their address with the court and with their creditors, so they don't get the notice of things that they're supposed to get. If you're not getting the information, if you're not paying attention to it, errors can happen and you won't catch them. Next slide. You can object at different stages of the garnishment process. You can object when the creditor first files something called an application for writ of garnishment. Your objections can be, wait a second, you've got the wrong John Doe. That's not my debt. Your objection can be, wait a second, you're supposed to give the right form that applies Proposition 209, and you haven't done that. You can object when the employer files its answer. That's the form that I just went over a couple of slides back. Make sure that they checked off the right box, applied the right wages, applied the right calculations for things. At some point in the garnishment process, a creditor can ask for a continuing lien, which means they don't have to file a garnishment every pay period. And you can object saying, wait a second, I never earn enough to be garnished. This should stop. If you're going to object, like I said before, you have to keep your address current because you only get these papers mailed to the last address of record. And in particular, the most important time to object is when the employer files its answer to garnishment. That gets mailed to you, and you have 15 days to object to that. You go on to the Justice Court website, you look for garnishment forms. There's a very simple form to fill out to object. Next slide, please. And then the last thing I want to talk about is what isn't subject to garnishment. And Social Security, pensions, tax refunds are not directly subject to garnishment. A creditor can't get an order to Social Security to take some of your benefit before you even get it. They can't take money out of an IRA. They can't send something to the IRS to get some of your tax refund. But when you get that money and you put it into your bank account, it's no longer treated like Social Security pension or tax refund. It's just money. But the good news is Proposition 209 exempts $5,000 in your bank account. You can only have one bank account to apply this to, but $5,000. Be careful if you happen to get a large tax refund and the balance in your bank account goes above $5,000 and there's a garnishment order with your bank, you're going to lose everything in excess of $5,000. So if you want to avoid that, try to figure out ways to not have your bank account balance go above $5,000. I think that's all I have. Next slide. That's all for me.
Great. You can put your questions again in the Q&A for legal information questions. And while we're doing that, I'll just give you exciting news that we have been authorized to have legal services authorized community justice worker. And why this is relevant to today's conversation is that one of the areas that they can practice in is debt relief and garnishment. What these are non-lawyers that are trained and supervised by Community Legal Services, DNA or SALA. You will be getting, if you're a community partner, you'll be getting information on this in February and March. We have a soft opening right now, having our paralegals being trained in this right now. However, we will be opening this to the community. So if you're a caseworker, maybe helping people already with different types of garnishment issues, you might want to consider becoming a community justice worker, a legal services authorized community justice worker. Again, we will train you, and then if you are trained, you can become authorized to assist our community with limited legal assistance, again, under the supervision of attorneys at CLS, DNA, and SALA. We will be discussing this more down the road, but wage garnishment is one of the issues that we can train and supervise you about. We are now going to look for questions.
Pam, I answered one. Someone had asked about getting a copy of the PowerPoint. I typed my email address in there. You can email me if you want a copy of the PowerPoint, but I think it might have disappeared. I don't know if you guys can still see it, but my email address is kyoung, Young, at clsaz.org. O-R-G. So just email me if you want a copy of the PowerPoint. I'll send a PDF. And then, Pam, I can go ahead and read these if you want.
That's excellent. Thanks, Connie.
Okay. So Diane asks, which taxes are subtracted to obtain disposable wages? State and federal and FICA?
All.
All of
Anything
the above.
that law requires to be deducted from your check is subtracted. And you can sort of see that you can control your withholding to some extent. And the more that you withhold, the less that's in your paycheck. But then the larger the tax refund you get at the end of the year, which could raise your bank account balance above $5,000. So the ideal thing is to, if you have a debt and you're going to be subject to garnishment, withhold if you can enough that you don't earn disposable wages above the exemption limit.
Okay. And then the next question, can employees' work address be used for mailings and notices?
Yes, you can use whatever address you want. You can use your parents' address. You can use your uncle's address. You just have to have an address that you're going to check the mail at so that you get the mail.
And as you stated, it has to be the court address, right? And
Well,
or the
you know,
address used in the court case?
no, it has to be your current address.
Okay.
So you might be getting sued on a debt that's 10 years old. The credit card company has your address from 10 years ago. They have to serve you with the lawsuit to get the judgment. And let's say you just say, I've got no defense. I just default. I don't respond to it. They just have your address from 10 years ago. And then when the garnishment starts and your employer files the garnishment answer, if you haven't updated your address, that they don't have the right address on the garnishment writ, maybe your employer doesn't have your current address right, you're not going to get the answer. And you want to get these documents so that you can look at them.
Okay. One of our other superstar VLP attorneys, Diane Drain, makes a comment. She says, note, the new exemption as of January 1st, 2026 for one bank account is now $5,600 because the annual CPI adjustment.
Great. Thank you, Diane.
And then Anonymous, are you going to discuss the ability of a judgment debtor to request that the percentage being garnished be reduced?
No. And I think that it would probably be hard to do it because the percent being garnished only applies when your disposable wages are above 1,818. I think the courts, I don't know this, may still have some discretion if, let's say, you've got a number of children that you have to support and you just need more money than the average person, you could ask the court to reduce that percentage. But the way the law stands now, it doesn't talk about discretion. As I read the proposition, it just says 10%.
Okay, and then the next question, I have a few disabled veterans that have been garnished for past child support or debtors. What is their legal recourse? Sounds like a client question.
Everything I've said doesn't apply to things like child support. It only applies to judgments on unsecured debt like a credit card debt. Child support payments are really treated more like that money isn't yours. Uh, it also doesn't apply to liens that the IRS puts on your paycheck.
Okay, the next question. Don't banks typically look to see where the funds come from and if they are exempt, SSI, for example, and then notify the judgment creditor that they are out of luck?
I don't think so. I think once the money's put in your bank account, it's money. And when they say that they can't garnish your tax refund, what is meant is a garnishment order can't be sent to the IRS. When they can't garnish your Social Security disability, a garnishment order can't be sent to Social Security. But once the money's put into your bank account, it's treated just like any other money.
Okay, does the judgment creditor have to know your social security number to accomplish garnishment?
When when there's a judgment against you, the judgment creditor has a right, even though you're not required to respond to the summons, you can just default. When they get a judgment against you, they can do what's called a judgment debtor exam. And under oath, you have to tell them who's your employer, who's your bank, things like that. In my experience, the creditors already know all this. When they file the lawsuit on a credit card that's in default, they already know who you are and they have all that information on you and they know this. Um, if this was a debt that was totally not due to something you applied to, you got sued in an auto accident and someone has a judgment against you, they don't know anything about you at that point, and they may have to do some work to find out.
Okay. If a creditor is calling for payment and you ask them to provide a statement of the debt, you provide a current address and they do not send the statement, and you asked and record them several times asking for a statement of the debt. What happens? Can they issue a garnishment?
They issue the garnishment when they have a judgment. So a judgment comes after they call you on the phone and say you owe money and whatnot. In order to get a judgment, they have to file a complaint saying that you owe them X dollars. If you don't respond to that summons, if you don't answer, they get a default judgment. They don't have to offer any proof. If you contest it and you say, I don't owe this, then they have to supply their accounting to show what you owe. In a lot of cases, the creditors will include that information in the complaint before they're even asked for it.
Okay. And Anthony Clark, one of our awesome CLS attorneys, asked that this is a great question. How does the new limitation affect student loan garnishments?
I don't think it does.
Okay. And next, so they do need the social security number, right? Just follow up on that one.
Well, when you apply for a credit card, you're giving that to them. So if it's the kind of debt that's a credit card type debt, they've got that. If there's a judgment against you in some other way that they didn't get that, they have a judgment. They need to, you could challenge them when they garnish you and you could say, that judgment isn't me. Yeah, my name is John Jones and I lived in Glendale on that street, but that's not me. And I don't know how they would overcome something like that because when there's a judgment against you in court, they only have your name and they might have the county that you live in, they might have the city that you live in, and the judgment doesn't identify you any better than that.
Okay, I don't see any other questions. Are there any other questions? I will just say my email one more time. It doesn't look like you guys have access. So there is a response here. Thought there is a judgment information sheet. Same person asking about the social security number. Thought there is a judgment information sheet. I
I,
think
I don't know what that means.
they're asking maybe if that's where you have to put identifying your address, name, and all that, but
You
you're
don't
not.
have to do anything unless the court orders you to do it. You don't have to respond to a summons. The consequence of not responding to a summons is the court issues the judgment requested in the complaint. But you don't then have to go and give them information unless you're ordered to do it. And the creditor who's holding a judgment has the right to order you to do that, but they have to take those steps.
And Robin Dugas, one of our formal CLS attorneys, states
And
judgment
classmate.
judgment info sheet is for recording the judgment. So that's the difference. I don't know if you want to talk about recording or
No, I
yeah,
don't deal with that,
a whole
but
other.
yeah.
Separate webinar.
Okay.
Is that all of our questions, Connie?
Yeah, I'll just give my email address one more time. If you want a copy of the PowerPoint, just because I know there's nowhere to put it where everyone can see it. So it is K Young, Young, at clsaz.org, O-R-G. Thank you all for coming. Thank you, Andy, again for giving such a great informative presentation. We appreciate you. And Pam, I think you have some closing stuff to say.
Sure. Again, you can apply for services. If you need legal advice or legal assistance, you can call us at our phone number here. You can go to our website to see our information. Also apply online at AZ Law Help. If you prefer to go in person, in all of our rural offices, there's opportunities to apply in person. And then here in Maricopa County, Tuesdays, we are in Peoria. Wednesdays, we are at Native Health. And Fridays, we're in Mesa. You can go in and apply in person, bring your paperwork, and you can apply to receive, again, legal assistance, legal advice. Again, we do these the last Thursday of every month. Please look on our Instagram and our social media to see a list of upcoming webinars. As Connie mentioned, we have a very robust volunteer lawyers program that we're always seeking volunteers. We are never going to turn down a donation either. So here's also a way to donate. And again, you can look on our social media to hear more about the work that we're doing. Thank you. And thank you so much, Andy. Again, I second everything that Connie said. This was very, very helpful. It will be on our YouTube channel so that you can review it. Thank you so much, everybody, and have a great day.